Adjournment requests, if any, from item number 1 to 6. Item number
Lordship,
7 to 18.
with the consent of my senior Lordship, I beg to mention item number 5 to 9, Lordship. Lordship, this matter come after vacation, Lordship. This matter, Lordship, the conducted counsel, he is out of station due to medical emergency, Lordship.
I think not less than 10 times. Always.
I'm not in the matter, Lordship. I was instructed by the conduct counsel.
It is.
After the vacation. After the vacation.
10 to 18.
May 15. May please, your Lordship. Yeah. Item number 15, my lord. 15. 15. Yeah. In this paper, my lord, against the same judgment, another appeal is also filed, my lord. The appeal by whom?
By the state.
By the state.
I am appealing in that case.
Two matters.
Both these cases may come up together, my lord. Judgment is same judgment. The number of questions.
3 appeals, not 2 appeals. 3 appeals have been filed against the same.
I'll give the
Along with supply the text. Yes.
Alright.
Yes.
19 to 28.
No, I pray for listing of an IA.
Yes, sir. At the
I was thinking,
as regards item number 26, and with content from the other side, I pray your Lord, the matter may be taken up after certification. Person 26, your Lord. Who is the person difficult deputy? With content from the other side. Item number 28, Lord. Affidavit has to be called. Has to be called out. 28, Lord. May I give a
you
request?
already filed the
Yes, Lord. Oh, affidavit.
Your Lordship, I beg to mention item number 21. Kindly adjourn for the day.
Item number
21.
It's 14
Password for the day.
so the day, so what you have to,
Yes.
you have to satisfy that.
Your Honor, I am not the conducting counsel. Senior counsel is in hospitalized. A Bhattacharya. And he informed me to inform the matter before the loss.
Item 29 to 41.
May it please the Lordship. Lordship, with the consent of the other side, Lordship, may I pray that item number 33 may be adjourned for the Lordship. 33.
Only my date may be, not 23rd of October.
Date you are.
23rd of.
Okay.
My lord, I pray for adjournment in item 31, Lord. Some difficulty, my lord, will come up next week, my lord. Oblige.
Any other requests?
Not one.
May I please Lordship? Lordship, by taking consent from the other side, I beg to mention item number 38, Lordship. Lordship, my senior is out of station. Lordship, may kindly adjourn the matter for today.
On IA, my lord, it was listed before this court for correction of petitioner's name. The Honorable Justice Nair cannot take up. So your lordship directed to this the matter before any other court without Honorable Justice Nair, my lord. So another bench is available, may I pray, ma'am.
The bench is not available for the big commission. Never. What I am paying for,
Second place,
what was the competition?
your lordship's order is, my lord, list this matter before any other bench without Honorable Justice.
Big correction.
Yes.
Correction in the order. Which bench has passed the order?
Correction in the name, petitioner's names.
But which,
Not order.
which bench has passed the order
This honorable court has passed the order to list the matter before. Yes, yes.
along with whom?
Along
We
with
along
Honorable
with
Justice,
whom?
along with Honorable Justice Nair.
Oh, that, so the original order was passed by which bench? Which you now want to be corrected, which bench has passed that?
What has happened or not, no order. I'm not seeking correction of any orders. In the petition itself, the writ petitioner's name is wrongly, the title is wrongly written. She has written the title of her husband. It should have been the maiden, her maiden title.
So now you have filed an appeal.
So application for correction of petitioner's name, title.
That could be for the next time, जब भी whatever the combination will get,
Well-
the matter would be listed.
My pleasure, Lord. I'm paying for a listing of a place admission matter for on Friday, Lordship.
On
On Friday, Lordship. Lordship, in this
Why?
case, Lordship, in
What's
this
the
case, we have, Lordship, in this case, we have challenged the Amendment Act of Missing Autonomous Council as well as the draft delimitation order, Lordship. By including the non-missing people, Lordship. They are on
you're
30.
challenging the validity
Yeah.
of the act
Yes, Lord.
next week.
Lordship, on 30, they are going to publish the final delimitation order, Lordship.
So we are not
Lordship,
going to
Lordship,
stay,
Friday,
we are not going to stay.
Lordship,
the state.
earlier also challenged, Lordship.
My lord, in this case, what had happened, even villages with zero missing population is sought to be
But to be,
included in the missing autonomous council. Where 0% is.
the
My lord,
validity of
actually
the
what had
act is
happened,
under
my lord,
challenge. Validity of the act is under
no,
challenge.
my lord, the issue is, my lord, now there is a concept of core village, satellite village.
So we have, naturally, we have to challenge those provisions, otherwise our challenge itself would be
Next week,
on Friday, my lord.
next,
May it please your lordship. Lordship, I want to mention item, lordship. On the last day, when it was listed on 9th of September, lordship had directed to list it after a week. It has not been listed.
next week, madam.
Much obliged.
Uh,
Lordship.
yesterday, a matter was heard and judgment entered. Lordship allowed me to submit list of judgments.
Give it to the
May I please, Lord? My Lord, I may be permitted to move an urgent writ petition tomorrow. It has been already,
Who has prevented you from moving?
pardon, Lord.
Who has prevented you from moving that? Move.
No, for listing, listing, Lord.
Nobody is preventing you.
For listing tomorrow.
What's the urgency?
Urgency, this Lordship, the bank has issued a notice under section 13(2) of the SARFAESI Act. And we had filed our reply, Lordship, objection as required under section 13(3)(a). The bank has not given any reply, Lordship, till date.
Fine.
And thereafter, Lordship, they had issued a position notice under section 13(4). So that is not, without giving reply to the objection of the borrower, Lordship,
Point it out to the debt.
Lordship.
Challenge the same before the debt recovery tribunal.
No, Lordship. The effectual judgment, recent effectual judgment in this, Lordship, if the bank does not comply with the provisions of section 13(3)(a) of the SARFAESI Act, Lordship, that in that event, Lordship, the position, symbolic position notice under section 13(4) cannot be issued.
The High Court can quash that notice.
Lordship.
The High Court has power to quash that notice.
Yes,
High Court
Lordship.
can exercise
Where
power
the
to-
mandatory provisions have been violated, Lordship.
Maybe, sir.
No, Lordship, allow me to move. If Lordship will not be satisfied, then my petition can be.
File the petition.
I have already filed.
But
Obliged.
May I please, Lordship? Lordship, with the consent from the other side, I'd like to adjourn the item number 36 for the.
John,
Item 124.
May it please your lordship. Okay, that's fantastic.
Item number 2, I have entered appearance today, madam. I would like to file an affidavit indicating my stand. Two, madam. I have entered appearance today, madam. I would like to file an affidavit indicating my stand.
Superintendent of Police so and so.
Right.
All these applications, what you are seeking in all these applications?
Lordship, we have filed this IA seeking direction from the honorable court to allow us to investigate the case. We have registered the case. Yes, Lordship. That is,
Where is the necessity of seeking permission?
there
from
is
the-
no, actually, this arises because of a direction passed by this honorable court, by a single bench of this honorable court, Lordship. In WPC, Lordship may kindly have a look at this IA 4156,
4165.
4165, Lordship.
Yes.
Page number 39. Also, this writ petition has been filed by one of the respondents for quashing of the FIR, Lordship. Subsequently, this order has been passed in 18/2/2019.
Which order you are referring?
I am referring to page number 41, Lordship, may kindly come 41.
Yes.
Lordship, it is an order passed by, Lordship, I'm sorry, Lord, not 41.
Order.
Lordship, page number 66.
Criminal prosecution and court, that your input from this court.
We have withdrawn as because there is no necessity of section 17A. As because there is a direction of this honorable court, there is no requirement. Therefore, we have withdrawn. Subsequently, writ petition has been filed by one of the respondents. That writ petition, Lordship, may kindly come, Lordship, in page number 66.
Yes,
WPC 5476.
Yeah.
That writ petition is crossing of the FIR, Lordship. However, Lordship, in this writ petition, a direction has been issued. Lordship may now come to page number 70, Lordship.
70.
70, Lordship.
Yeah.
Second para, Lordship. Mr. Kyle has produced the departmental record. May I read, Lordship? To contend that since the matter has proceeded as per the direction issued by the honorable court, there was no further requirement to obtain approval under section 17A of the Amendment Act of 2018. The learned counsel has not cited any other reason for not obtaining the approval or for withdrawing the IA 266/2019 earlier filed by the CBI. However, the learned ASGI has made a categorical submission before this court. The CBI would be open to obtain necessary approval from the competent authority, even at this stage, before proceeding further with the investigation. In view of the submission made by the learned ASGI, it would not be necessary for this court to go into the merit of the contentious issue raised by this writ petition. With the consent of both the parties, I therefore dispose of the writ petition at the stage of motion hearing by granting leave to CBI to take immediate steps for obtaining approval. So there is a direction which has been made to CBI to take approval under section 17A, Lordship. And accordingly, we have filed a application, Lordship, before the competent authority, which has been rejected, Lordship. Now the approval for granting to investigate a case has been denied.
You have moved application before the competent authority.
Yes, Lordship.
That has been
Rejected. Therefore, we have filed this IA, Lordship. I कुठे किती आहे? कुठे किती आहे हे तू एक.
Your argument that since the this case was registered as per the direction of this court,
Yes, sir.
therefore there is no requirement of taking approval.
Right, sir.
Is there any
Yes, yes. I have submitted those case laws, Lordship, before this honorable court. Lordship may kindly have, it is on record, I think. I have referred some judgment of honorable apex court, Lordship. State of West Bengal and others. Oh, no. 2010 3 SCC, Lordship. With the judgment of Constitutional Bench of Honorable Apex Court, Lordship. State of West Bengal and others versus Committee of Protection for Democratic Rights, West Bengal and others, Lordship. Lordship may kindly come to para 68. Para 68.
Yes.
Certain
My lord, can I just comment it up? My learned friend's contention that since an investigation was directed by this honorable court is not correct. Absolutely incorrect statement.
Lordship now may kindly come to page number 601.
Yeah.
601 of the judgment, Lordship.
601?
601, next page, immediately after the 601. Clause 7, down below, Lordship, last para.
Yes.
When the Special Police Act itself provides that subject to the consent of the state, CBI can take up investigation in relation to the crime which was otherwise within the jurisdiction of state police. The court can also exercise its constitutional power of the judicial review and direct CBI to take up the investigation within the jurisdiction of the state. The power of High Court under Article 226 of the Constitution cannot be taken away, curtailed, or diluted by Section 6. Here in this case, the question is whether consent was required or not. Section 6 of Special Act.
irrespective of there being any statutory provision acting as a restriction on the power of the court, the restriction imposed by Section 6 of Special Police Act on the power of union cannot be read as restriction on the power of the Constitutional Court. Therefore, exercise of power of judicial review by the High Court, in our opinion, would not amount to infringement of either of the doctrine of separation of power or federal structure.
Now, towards that, towards this criminal proceedings that initiated as per the order.
Order.
Which is that order?
Yes, Lordship. That is in page number 13, Lordship.
1-3.
1-3. The last page may be looked into, Lordship, page. Twenty-two, 21, starts from 21, Lordship, down below, Lordship. We accordingly, last line, Lordship, page 21,
Page 21.
1, down below, last line, Lordship. We accordingly, with the Lordship got it.
Direct.
We accordingly direct the Central Bureau of Investigation to have preliminary inquiry. And in case the allegations are found having some substance, warranting further proceeding with criminal prosecution, may proceed in accordance with law. So there are two directions. First, we are required to conduct a preliminary inquiry, and if it was found to have having any substance, we will have to proceed according to the criminal proceeding.
That but before the single
Lordship.
you have speak for this seeking permission for this
Lordship, that is not perhaps misinterpretation of law. Maybe, Lordship, at that point of time I was not there, Lordship. Someone else appeared.
was not there.
That was the error, Lordship. That was an error.
The part
Erroneous order, Lordship, as per my submission, Lordship. That petition has been filed for quashing of the FIR, but the order has been passed, whereby we are directed to take approval of it. I don't know, Lordship, how that order has come into being, Lordship. Maybe, Lordship, the law was not in place properly before that court.
detected for
Lordship, that is page 78, Lordship. Lord, 71. This is our application, Lordship. Rejection, Lordship, they have filed an additional affidavit. Affidavit they have filed in this case, Lordship. There they have annexed the rejection order. Affidavit has been filed by the state, Lordship. Lordship. An affidavit in filed by the no, Lordship, 27/1/2020, Lordship. (27/1/2020) is the order. In their affidavit, Lordship. Did your Lordship got that affidavit filed by the state of Arunachal Pradesh, Lordship? It took 4165. If you Lordship take 4165, my second, I would like to file my affidavit with the fact. page number 9 of the decision. 7. Start from the order was annexed, Annex A. Page 4. Start from page number 4 till page number 7.
There are two orders. In fact, there are two affidavits by the Chief Executive of Respondent. One is of 18th of January 2000. Effect of six. Another is one of February or 8th of February 2020. Orders are passed. How many cases were there?
4 cases are there, Lordship. 4 FIRs are registered. Lordship.
In all these 4 cases, you put in
Yes. Yes.
for the state of Karnataka.
Yes.
I am here, madam.
Milord,
You are for the state of Karnataka.
yes, I have.
How two orders have been passed?
Milord, subsequently there is another order pursuant to that order was passed. Milord, fact of the matter is, sanction under section 17A as well as 6 has been declined. Now, Milord, it is for the CPI to challenge those orders. Now, these proceedings have become, my lord, obsolete now. There was Milord, they are proceeding on the basis that there is a direction by this honorable court to register a case. There is no. Yes, if this honorable court directs, then there is no question of consent.
But after the order,
So, my lord, this honorable court itself has clarified that position.
what is that?
Yes, if your lordship would kindly have order dated 16/11/2017, whereby this taken the matter was closed. If your lordship would kindly have IA item number 266. IA 266. No, 1187 of 2020. I said. Please have Milord page 28 of that order. The division bench itself has ordered. We have directed only on preliminary inquiry. Page 28. This is the application filed by the CBI. Para 16, page 28.
Yeah.
Since our direction above is only confined to a preliminary inquiry and not an investigation by Central Bureau of Investigation, we have refrained from elaborating on the case law cited on behalf of the state. We have also deliberately refrained ourselves from commenting on explanation given by the respondent justifying allotment of the contract as well as completion of work. So that neither the inquiry nor in
What is the meaning of this observation?
of the
Accordingly, direct the Central Bureau of Investigation to have preliminary inquiry and in case the allegations are found to have been substantive,
yes.
warranting further proceeding with criminal may proceed in accordance.
Yes, in accordance with law, means they will have to seek section 6 of the Act as well as section 17A. And they file an IA which was subsequently withdrawn in accordance with law. No, yeah, 76. That was it. And Milord, if your lordship will kindly come to page 76 of the same very petition, Milord, where at a single judge of this honorable court, in fact, recording consent of both parties, this order was passed. Page 76. In view of the submission made by learned ASGI at page 76. Lordship.
Yes, they will get here. Let's take the whole, get back to the bed anyway. This action of further, the criminal may proceed in accordance with law. In accordance with law, that is, there is no conviction of the part of this court that you are not required to take action. And let me point it out. You before the learn on your own volition, said, yes, we'll take the permission from. Now it's agreed by this decline by the state government. Whatever the
Remedy is available. No, Lordship,
This can't be ignored now.
correct.
And otherwise, if you are agreed by this order also, then it's single just fine.
We need to challenge it. Now, one more, I just refer what my learned friend has submitted, Lordship. Now, whether section 17A will be applicable in this case or not,
Yeah.
that also will have to be looked at, because the
Okay.
current,
Not section 17A, then why you are seeking permission
No,
for the
that-
section 17A?
because,
Why you have
because
sought
because of the
permission?
direction, Lordship, because of this direction, Lordship,
Which direction?
single judge order, single judge,
Then challenge that order, sir.
that was not done because, correct,
It was
Lordship,
not
because
done
one more.
when, that has attained finality, whatever, it may
wrong
be,
back.
wrong, right, whatever it may be. Now, these applications are, we can't go into all this. We can't review that order of the learned single judge. Then you yourself on your own volition said, "Okay, you will seek permission."
No, we have
Now,
not,
if you are agreed that
Lordship,
no permission is required, challenge this order.
no, but before the single judge also, we have not stated so, Lordship. Lordship, we have stated that if required, Lordship,
No, sir. Please, now
Lordship,
come to that.
page number 76,
Page number
76,
76. Come.
page number 76.
However, learned ASGI made a categorical submission before this court that the CBI would be open to obtain necessary approval from the Cooperative even at this stage before proceeding further with the investigation. What is this? Categorical submission.
Open to obtain, Lordship. That means open to obtain. We have not stated we
Open to obtain and
Yes.
in accordance
If
with you
necessary.
also this applied for this prescription.
because subsequently in the subsequent paragraph, Lordship, we are directed.
In view of the submission made by the, it would be necessary, it not be necessary to maintain, so they consider therefore dispose of this stage of motion, granting leave to immediate step or so. You are agreed, so you could have challenged that order. Now this via application,
Lordship,
we can't
I
review this
understand,
order.
Lordship. That was the lacuna which has been,
We can't review this order. Chief review of this order is not permissible by way of IA. Yes. Okay, proceedings, whatever.
one more thing, whether, Lordship, the division bench judgment, Lordship, which is in passed in 2017. The Lordship, admittedly, the occurrences of 2010, Lordship. Occurrences of 2010. This amendment to 17A has been enacted after 2018, Lordship. 2018, whether this law is applicable in this case or not, Lordship. 17A is
But it is either to challenge this order 8/8/2019 or to avail appropriate remedy whereby they have refused to grant this.
Okay, one more thing I would like to, but in page number
Now
28.
you became now you became wiser now, and now you are raising all these contentions.
No, Lordship, this thing has come to me subsequently. I was not there, Lordship. It was,
We are not concerned with the advocate.
correct, Lordship.
Ultimately, the part is.
Okay.
You are changing your stance. You on your own position before they said before the learned single judge, yes, we are ready to seek permission. Not also. You applied for that.
That was what, I won't make any comment, Lordship. I don't know
Take
how
the
that,
remedial measures. We are not here for having this advisory jurisdiction, but whatever it may, either you are agreed by that order that single judge move appropriate proceedings, or if you are agreed by this refusal order, then IA
Because direction is by this division bench, Lordship. So therefore, we have filed it in the-
Direction is also very clear. That's why I have mentioned, since our direction is above only confined to the preliminary inquiry and not an investigation. They have clarified.
I understand.
Withdraw it and but
Lordship may pass an order, Lordship.
what order? On merit?
On-
Are filed on behalf.
Lordship, Lordship, may I take an instruction for before?
When?
Let it be after vacation. Lordship.
Why after vacation? You take instruction by tomorrow or day after tomorrow,
Day after tomorrow. Day after.
day after tomorrow.
Kali.
Item number 10.
Highly obliged.
Notice upon the respondent number 6 has been received. Who is appearing for the respondent number 6? Respondent number 6. You are appearing.
Your Lordship, I'm appealing for respondent number 7, Lordship.
Respondent number 7.
Yes,
Notice
Lordship.
upon the respondent number 6 has also been served. School selection committee. the notice upon the report of the duty which of the output, despite such of their mistake. That is attributed for after.
Interim order is there.
Interim order is limited.
Interim order may be.
Is it limited? Not limited.
Item 11.
May I please the Lord? What is the contempt application coming for the first time? The order your lordship will find at page 8.
Item 12.
Number 12. That's phone number. I have 6 and 7 lordship.
Yeah.
Has not been acted. Lordship, that's phone number 6 and 7, they have already ever in this regard lordship. Willful and deliberately have not been acted.
Yes, you are appearing for.
I'm appearing for lordship, Mineral Development Corporation lordship. 2, 3, managing directors, 2, 3, 4, 5. And these are also our officers lordship. They are in personal capacity.
These 3, 6, and 7.
And 1, 4, 5. It's our officer.
Managing Director, the Assam Mineral Development Corporation.
Yes, I'm appearing.
And
4 is also.
6 is Mr. P. Temple, Inquiry Officer.
This is our officer lord.
And 7 is Inquiry Officer.
Our officer lord.
You are appearing for all.
All. But here lordship, 4 and 5 also I'm appearing, not 10.
4, 5. You are appearing for respondent number 2, 3,
2 to 7.
2 to 7.
All.
And he is appearing for respondent number 1. You are appearing. So, what do you want to say about this?
I need some time lordship to give a reply with this.
This is a condemnation application.
Yes, lord. Condemnation of delay lordship.
There are 4. Lordship, here in this case lordship, the learned single the lordship.
There are 4 cases. Donation of
You want to find logic?
lordship. Yes. Highly obliged.
So lordship, we do respect lordship.
Yeah.
Lordship, we do respect lordship. So learned single the lordship. Only directed to the discharge.
Let the delay
Yes,
be controlled,
yes,
then only we'll hear your merits.
Yes, sir.
411.
Master,
Item 13.
May I please, your lordship, my lord, may I pray, my lord, this matter may be taken up after a while, my lord.
Taken up?
After a while, my lord, Mr. H. Gupta is on legs in court number 24. my lord.
Notice.
Item 14.
My lord, my humble submission is this matter will require some hearing. my lord. After vacation. my lord.
I have no objection.
At the request of the
In
council.
fact, my lord, I think I'll have to study a lot of history to argue this case. my lord. Because this concept of coronia has a different, connotation in the Assamese context. We'll have to go back to Hong Kong. my lord.
But the issue is not that now.
The issue is that only.
Thereafter, after till 18th, he was coronia. Next day, he became a different.
How many certificates in it?
No, my lord, anyway, I keep it to myself.
Till
Just
18th,
now,
till
just now we're discussing that. only.
till 18, he was coronia. 19, he became Rabha. And after 1 week, he became a general candidate in Bihar.
Bihar.
He will contested the election from
No, my
Bihar.
lord, actually what happens, people like us only advise them. Problem is that.
Overnight, he
honest.
changed his.
To be honest, my lord, people like us.
That is why a subsequent affidavit about his status may be required in this case.
And my lordship will test the case with reference to his original thing.
The original case has diluted, Lordship.
Let us see.
Highly obliged.
At the
Deeply
request of the then council appearing for the appellant, place this matter of Puja Vich. November.
Item 16.
Number two. W80 of 2020.
Is that already met us?
Yes, yes, yes,
Yes,
yes, sir.
Still, I'm not, the date is- yeah, it up. But- Okay. Published along with returning number 50 of
Eight-
2020.
80 oblique
50 oblique
80, my lord.
80,
50. Get it confirmed.
2024. 2024.
50.
50.
Oblige.
Right.
Item 17.
Wait, it continue. My lord, the appeal has become infectious, my lord, because the NIT dated 3/8/2024, my lord, that has already been cancelled. my lord.
But also for the data bit that became just dismissed the
Oblige.
Item 18.
Need, please.
Lord, the case of the petitioner before the learned single judge.
my lord will find page number, my lord. '83. My lord will see, my lord, paragraph 3. My lord. Yes, my lord. My lord, the case of the petitioner before the learned single judge, your lordship will kindly
He worked as a
SPO
SPO for 5 years.
for 5 years during that ethnic conflict, my lord.
Whatever.
And therefore, in terms of the advertisement dated 13/12/2017, my lord,
He
is
required to
entitled
give, 10 marks.
full quota of 10 marks. And had that full quota of 10 marks been awarded to me, my lord,
He could have
as an
selected.
OBC candidate, my lord, I would have been above the cutoff, which was 52, my lord.
Fine. So how you are claiming these 10 marks?
That 10 marks, your lordship will see at page 83, my lord. Page 83.
Yeah.
Paragraph 3. Paragraph 3, my lord, page 83.
Yeah.
That the petitioners beg to state that the petitioners were initially appointed as home guards after undergoing rural basic home guard training in 2002 and was subsequently appointed as a SPO, special police officer, in the year 2008 under section 23 of the Assam Police Act 2007. Accordingly, the petitioners engaged as SPO in Cooperative district during the 2012 ethnic problem from 1/8/2012 for a period of 5 years.
Is that certificate?
That certificate, your lordship will find at page number 97, my lord. In fact, I have annexed it at page number 18.
Yeah.
97, my lord.
But there it says that you worked for 5 years.
If your lordship may just read out page number 97, my lord. This is to certify that ex-home guard Ritumoni Bora, son of so-and-so, my lord, was engaged as a SPO in Kukraja during 2012 ethnic problem, while later number so-and-so. 1/8/2012 of the Additional Director General of Police Admin Guwahati and government letter number so-and-so dated 37/2012 with professional commitment, devotion and utmost sincerity, I wish him success. And the date below, your lordship will kindly note, my lord, it's 24/12/2017.
That doesn't mean that
And-
you worked up to 2017.
In fact, my lord, the statements and averments which have been made at page number 83 has not been disputed. In fact, my lord, even in the
Okay, that has not been disputed, but there is the admission that yes, you worked for 5 years.
yes, my lord, if they are not controverted, my lord, that will be deemed to be admitted, my lord. If your lordship,
Not in every case. Not in every.
if your lordship kindly peruses, my lord,
And
just for,
ultimately, you have to prove your case. Can't
that is there.
depend upon
I have,
their reply or whatever it may be.
My lord.
You have to prove your case that I worked for what
My
are
lord.
other documents which you are ready.
your lordship is absolutely correct. And therefore, I have made a specific averment at page 83. And my lord, that was neither disputed.
You have to certify the court that you worked 5 years, but it's 5 years. Show us any other document except this. This is not.
In
right,
fact,
right.
In fact, my lord will see. In fact, my lord will see, my lord, in a similar certificate at page 33.
Yeah.
Page 33, my lord. A similar certificate herein, identical certificate, full quota of 10 marks was provided.
That means you have to prove your case if they have illegally or wrongly granted any consent, not create any right in the.
That is there.
And the learned single judge has already ordered for this, by another order dated 10/7/2024. The court has ordered
The re-verification.
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 Verified it.
Re-verification, they have verified, but they have not taken into account.
There are a number of litigation, lead case was being so and so. Because Bania and 5 others, which were disposed of by a common order 10/5/2020.
That is there.
As per the same, the certificate experience of Hogart, where no period was standard practice or were done in the district of Cooperative.
Program.
This is what, where is that order dated 10/5/2024?
That your lordship will find at page number 71 and 72. 10/5/2024, my lord, will find at page number 71, operative portion is 72. Now 72, paragraph 9, if your lordship kindly turns, the second but last para, therein it was stated that let the aforesaid exercise be undertaken and completed within a period of 2 months from today, and consequential action for affording appointment to those candidates who secure more than cut-off marks be made expeditious thereafter.
That's correct. It's quite, governed by this 10/5/2024.
10
No, period was specified in your, this certificate, and therefore 2 marks they have rightly granted, and after granting 2 marks, you have not been able to, cut across, this, cut-off, marks.
Perhaps that is where the error lies. Now, if your lordship kindly takes up the impugned judgment at page 164.
Yeah.
Page 164 is where the impugned judgment is, and fourth paragraph from the top, my lord. My lord will kindly see, my lord. Shri Goswami, learned state counsel, by referring to the written instruction that so and so has submitted that the candidatures of the all 3 petitioners were verified, and was found that none of the petitioners were eligible to receive the 2 marks for certificate as home guards and SPOs as per the order of the Honorable Guwahati High Court dated 10/5/2024. So these instructions itself was erroneous, my lord.
Okay, that, we deem it that you are able to get the 2 marks. Then you, it's like,
I have got total marks 50, my lord. If your lordship kindly turns, my
what is the cutoff?
page 31, 52 for OBC,
52 for OBC.
page number 31, total marks, my lord.
Where is that, this, instructions or whatever this, return instruction?
That was not provided to me, my lord.
5/8/2024, that has been taken on record.
That was not a copy of that was not provided to me. Okay.
Your initial case was this, that you were awarded 2 marks. You could have, you should have been awarded 10 marks. Then only, how can you say that, after, including these 2 marks, you will be, able to achieve
My-
the cutoff?
My lord, my main case, your lordship will find at page number 83. This is my case. Page number 83.
Leave us.
No, that is my case.
Yes, we'll grant you 2 marks. Then you will be, you'll get, achieve that cutoff mark.
Because 50 is what I have been awarded. If 2 marks extra, I get 52, which is cut off, my lord.
50, including those 2 marks.
But-
initially, excluding those, 2 marks, you got, 48.
The total marks is shown as per the records, total marks is 50, my lord. If your lordship sees page 31.
And after giving benefit of 2 bonus marks, 50.
But the impugned judgment says that 2 marks also I am not.
Okay, fine, leave it.
That is what they
Leave
say.
apart that,
Yes.
even though if that 2 marks is awarded, you will be able to
52.
achieve the cutoff mark. No, not at all, sir.
52, my lord.
That
In fact,
up to-
my lord, may I just place it in this manner? My lord, what is my case before the learned single judge?
Come to para 5 or writ appeal.
Para 5, my lord. Para 5. My lord. Para 5. That a bare perusal of the aforesaid performance slip of the writ appellant indicates that the writ appellant was awarded only 2 marks for his experience as SPO, whereas it is an undisputed fact in the writ petition under appeal, the writ appellant was engaged as a SPO in the district of Cooperative for a period of 5 years, meaning thereby the writ appellant ought to have been awarded a total of 10 marks. In the event the writ appellant was awarded 10 marks corresponding to his experience as a SPO, he would have secured a total of 58 marks, which is well above the cutoff marks for ABC candidate, that is 52, my lord. That is my basic case.
So basic is that there is the question of this seeking 10 marks. Why you have asked for 10 marks?
Because I have spent, my lord, during that 2012.
That's another thing.
My lord.
Your case is that even after granting you 52 marks or awarding you 52 marks, you have not been able to achieve the cutoff mark.
I have got 50.
That was your case.
That is my case. That is my case, my lord. My case is I have got 50 marks. Had I been given marks in accordance to the experience, I would have secured well above 52. Your lordship will examine the matter.
They have already examined.
My lord.
What we are doing,
My
we are examining.
My lord.
What
My
we
lord.
are doing.
And my lord, I'm relying on to one judgment. Just one paragraph. Paragraph 9, my lord. Paragraph 9. 1993, Supply 4, SCC 46. May I just read out. The paragraph 9. The aforesaid reply would show that on behalf of the respondents number 1 to 4, it was not disputed that 40% posts which have to be filled up by the promotion had not been filled up, and the denial of promotion to the appellant was justified on the sole ground.
You have to go somewhere.
My lord.
You have to go somewhere.
No, I don't have to go. My lord, my lord. My lord. I'll go slow, my lord. I'll go slow. Well, I'll go. The aforesaid reply would show that on behalf of the respondents 1 to 4, it was not disputed that 40% posts which have to be filled by the promotion had not been filled up, and the denial of promotion to the appellant was justified on the sole ground that she was not qualified to be promoted to LT grade. This shows that in the pleadings before the High Court, there was no contest on the question that the post of LT grade, which was sanctioned on August 29, 1977, was required to be filled up by the promotion for the reason that 40% of posts had not been filled up. Even though there was no contest on this question, the High Court had gone into it and had held that the appellant had failed to establish her case that at the time of appointment of respondent 6 by direct recruitment, 40% of total number of posts in the college were not filled up by promotion as prescribed by Regulation 5(2)A of the regulations. Now, this is important, my lord. Since no dispute was raised on behalf of the respondents 1 to 4 in the reply to the averments made by the appellant in the writ petition that 40% of the total number of posts had not been filled by promotion, inasmuch as the said averments had not been controverted, the High Court should have proceeded on the basis that the said averments had been admitted by the respondent. And therefore, my lord, my humble submission, my lord, that page number 83, because page number 83, your lordship will see I have made categorical statement. It is my specific case. That was my case before the learned single judge, that I have spent 5 years during the ethnic conflict as an SPO. And therefore, in terms of the advertisement, my lord, in terms of clause 3, my lord, clause 3A at page 25, I'm entitled, and this aspect was of the matter was not disputed. Even my lord, even in the impugned judgment, my lord will see.
So, which date you were appointed?
I was appointed, my lord, with effect from 1/8/2012 for a period of 5 years, my lord.
What is the exact date when you were disengaged?
That I have pleaded at paragraph, my lord, page number 2, paragraph 1.
Yeah.
Paragraph 1, page number 3 rather.
The exact date of disengagement?
with effect from 1/8/2012, my lord,
Up to
for a period of 5 years.
5 years. Then the date.
My lord, exact date I don't have, but
The
the
exact date, then you can't have this, all these vague statements, exactly for 5 years. How many years you have
no,
worked?
my
Then
statement is specific.
5 years, 2 days, 5 years, 1 month, 5 years, or exactly for 5 years. There is a appointment order which says that you are appointed for 5 years.
Appointment order doesn't
These are
indicate
all vague statements.
1/8/2012 for a period of 5 years. And this, that's all, my lord. These are the specific, these are the statements and amendments which I made. This was my case before the learned single judge. And this aspect of the matter was never gone into. That is my.
What? 98, 2024 passed it. Which, but it, thereby, filed on behalf of the, you are here, 3 applicants are here.
My lord, only one of them has come. The first petitioner has come before
On
your
behalf
lordship.
of the appellant and 2 other persons. So, the case set up by the appellant is the to the effect that in connection with the recruitment of filling up 145 numbers of constables in the GT by constables GT in the exam security form. The petitioner that the appellant has participated. However, he was not awarded marks for the experience gained by him as a SPO. What is the full form of SPO?
Not a special police officer.
Special police officer. For the period he worked, for the period he worked. So, the case of the appellant, the appellant has contended that he worked as a SPO for a period of 5 years in Cooperative district during ethnic violence. However, the respondents have illegally awarded him only 2 marks against such experience, whereas as per the conditions of the he was required to award, he was required to, he is entitled to get 2 marks each for every year he worked as a PSO. The specific case of the appellant before the learned single judge that he is entitled for 10 marks against the experience gained by him at SPO. So, it to be noted that if the certificate submitted by the petitioner issued by the superintendent of police, it is only mentioned that the appellant was engaged as a SPO in Cooperative district during 2012 ethnic problem. White letter dated 1/8/2012 / 30/7/2012. However, however, the period for which the appellant has worked as SPO has not been clarified. Full stop. In another batch of petitions, this court by passing. This court has passed an order dated dated 10/5/2024 and directed the respondents to award 2 marks to the candidate who have worked as the SPO, but the period of their working as SPO has not been clarified. This court has issued direction to complete the exercise of awarding bonus marks to your candidates who worked as SPO without any specific date regarding their tenure within a period of 2 months. The respondents have conducted the said exercise and found that the marks awarded, the original marks awarded to the petitioner to the appellant are not liable to be paid. The learned single judge, after taking consideration the above facts of the case as filed by the appellant. When it comes to the appellant has submitted that in the writ petition, the appellant has made a categorical statement that he worked as a SPO in Cooperative district for a period of 5 years from 2012. It is contended that the said attention of the appellant has been disputed or controverted by the respondents in such circumstances. The said statement made by the in such circumstances, it's clear that the appellant has worked as 5 years as SPO Cooperative since 2012. And it also takes back on the decision of the Supreme Court rendered in the same month of state of UP and others before and it is argued that the Honorable Supreme Court has held that if the governments made by a person, if the governments made in the petition has not been controverted by the opposite side, then the said governments the said governments deemed to be adequate having deemed to be admitted of the concept for the not as therefore stated that the article that has had in not taking consideration the above situation. Therefore, if two order passed by the article that is able to be set aside and the writ will be filed by the report that deserves to be allowed the big rate for setting are to be granted. Heard the appellant through the petition available on the court. It is true that the appellant, the petition has made a specific growth that he worked as a SPO for 5 years from 2012. However, the period for which the dates from which he worked as an SPO and disengaged of the said engagement has not been specified. So, the government of this effect made in the writ petition are vague, and therefore we are told that even if the said government are not being specifically controversial, the same cannot be relied upon to rule that the Appella worked at the SPO for a period of 5 years. So, the appellant had to prove its case by producing evidence to the effect that he worked at the SPO for previous 5 years. See, previous 5 years of 2005. In view of the road, not same as therefore,
Obliged, deeply obliged. Item 19.
Lordship, matter relates to the advancements of the third MACP, Lordship.
Yeah.
The response is entitled from 2015. We gave him from 2010. We wanted to correct it, Lordship, and make some recovery. That has been negated by the case. Now, similar, Lordship, similar petition has been pending, Lordship. Lordship, on same issue.
how much amount is?
2 lakhs, Lordship, it's more than 2 lakhs, Lordship.
Criminal matter what it is?
On same issues pending, Lordship, from the same department, All India Radio, Lordship.
Why it is before the
No, Lordship, it's
division?
division bench, Lordship. 2,36,000, Lordship.
What's the okay. Regarding the act of heard 40% is serious protection to the response to the to the employee of All India
Radio, Prasar Bharati, Lordship.
All India Radio. It's pending consideration of the court, but, 2020. Where this court has by to the and state the order pass of the state the order pass of the that of its returnable effect of
Obliged.
this topic petition number 452. Correct.
Item 20.
The matter relates to misappropriation of government fund in welfare of tea and tea garden private Lordship. Lordship, this is the second set of litigation. Kindly produce page 133, Lordship. The order passed by this honorable court on 21/9/2021, Lordship. Page 133, Lordship. 133, Lordship. And relevant part is from page 137 onwards, Lordship, paragraph 14. Lordship. Page 137, paragraph 14, Lordship. Can I go quick?
Oblige, your lordship.
Yes, next.
22.
May it please your lordship, my lord, these petitioners, they were graduate teachers in ME schools earlier. And earlier they were governed by, my lord, 2003 rules. If your lordship can see that rule 14(2) of the 2003 rules, which provides, my lord, they can compete for the post of headmaster on the basis of their seniority. Now they have been amalgamated in the year, the school has been amalgamated in the year 2016. And ultimately that page 97, my lord, that is the condition of their amalgamation, page 97. Now graduate teachers of these ME schools, page 35 to look. Hold on, it up to-
It is 14.
Here, that your lot will get it at page 35 of this book. 14(2)A also your lot will can you see? 14(2), 14(1). As a result, my lord, your lot will can you see page 103. We are different graduate, page 103. Okay.
Yeah.
Okay. Page 103, they have taken into consideration the graduate teachers of the high school and assistant headmaster of the high school, but us, from the persons who have come from the ME school, we are working for a very long time, graduate teachers, same as them, getting equal pay, we are not considered. In this list, we are not there. Only the high school teachers are there. As per the rules, even the graduate teachers of the high schools are not eligible.
All methods. All that is perfect. Yes, sir. Okay. Copy of the supply. Madam, you are in receipt of copy of it. One copy I have, and extra copies I have required. Supply only one thing, my lord. If they can come up on record to show that their appointment were somewhere as graduate, that they will file an additional letter.
We have next copies of.
No, appointment letters have not been.
Published.
Page 103 should not be acted upon.
Published.
Item 23.
May it please, Your Lord. This petition is against an interlocutory order passed by the learned CAT, my lord, whereby the interim prayer was refused, my lord. Although the petitioner satisfied all the parameters for grant of an interim order, but nonetheless the same was denied, my lord. Well, before I take my lord to the impugned order, my lord, I'll very briefly narrate the facts, my lord.
Yeah.
My lord. May I, my lord? My lord, the father of the petitioner, my lord, who was a Safai wala working with the railway, he died in harness in the year 2015, my lord. Now, after his death, my lord, there were two women who were claiming to be the first wife of the deceased employee, my lord. My mother is Sipu Malakar and the mother of the private respondent is Purnima Malakar, my lord. Both of them had applied for grant of pensionary benefit. Now, initially, the railway had adjudged that the mother of the private respondent, she is the first wife, and hence she would be entitled for the pensionary benefit. At that time, the children don't come into the picture, my lord. Now, thereafter, my lord, we challenged that adjudication by the railways before the CAT. Now, the CAT reversed that order and came to a finding that my mother is the first wife. Thereafter, my lords, the purported second wife again approached the Honorable Guwahati High Court, my lord. Thereafter, that was reversed again, and the High Court had held that no, the railway authorities were correct. The railway authorities were correct that the mother of the private respondent is the first wife and hence entitled to all the benefits. But at the same time, my lord, when the judgment was passed by the Honorable High Court, my lord, the Honorable High Court observed that although we had declared the mother of the private respondent to be the first wife, but nonetheless, my lord, the children of both the wives will be equally entitled for all benefits, which is for compassionate appointment or pensionary benefits, whatever, because my lords, otherwise, my lords, the petitioner would be termed as an illegitimate child, my lords. So thereafter, after the judgment was passed by the Honorable High Court, we approached the railway authorities praying that my candidature for compassionate appointment my lord would find that judgment of the page 115, the operative portion of the judgment. the children of both the petitioner and respondent. I'm so sorry, ma'am.
Is not all the benefits.
Not all the benefits.
Pension rules only.
Yes, yes, as per pension rule. Well, I'm coming to that, my lord. But thereafter, my lord, I'm not on the pension now, my lord. Thereafter, after the judgment passed by the Honorable High Court, I approached the authorities filing a petition that my candidature for compassionate appointment should be considered along with my stepbrother. And there should be an assessment made who's more, who should, my lord, they should make an assessment and consider my case also as well as the private respondent. Now that representation was not acted upon, my lord. Thereafter, I approached the Honorable CAT again. The CAT gave a specific direction that both the brother and sister should be considered and one should be appointed. At least there should be a consideration. Now thereafter, my lord, when the learned tribunal passed the judgment, there was a personal hearing and thereafter the impugn order was passed by the railway authorities, whereby they had come up with a, my lord, a contention that my candidature cannot be considered. The reason being because my stepmother has nominated her son, but not nominated me. So that was the reason why my candidature ought not to have been considered
By the railway.
by the railway authority. Thereafter, I approached the CAT again, and I argued, my lord, and it was argued before the learned tribunal that the Honorable Apex Court has already settled the matter, my lord. It doesn't matter if you're the child born to the second wife, but both the children has to be considered equally. Now, in fact, my lord is aware, my lord, the Hindu Marriage Act was amended in the year 1975, and Section 16 was amended to say that even children born out of void marriages won't be illegitimate, and they'll be legitimate, my lord. And the other point which was argued, my lord, that if my candidature is not considered, it would amount to violation of Article 16(2), because there'll be discrimination on the basis of descent. And what I prayed, my lords, after showing the judgments, my lords, I'll come to the judgments if lordship desires, my lords. What I prayed that till the matter is disposed of, there should be the railway authorities should restrain themselves and not appoint any one of them. At least there has to be a decision, because if my stepbrother is appointed in the meantime, my case would become infructuous. And the order which is impugned, my lord would find it at page. Lordship may kindly come to the order. What was passed, my lord? In fact, if I may say so, my lord, with the deepest respect, my lord, the order itself is perverse, my lord. The first paragraph, page 140. My lord, would see the first paragraph, my lord. The instant petition has been filed by the applicant, being aggrieved with the speaking order dated so and so, passed by the respondent authorities in compliance of so and so, passed by the tribunal so and so, by which it was held that the applicant was not eligible for compassionate ground appointment since she was not nominated by the deceased employee. That was not the case. She was not nominated. But in any case, my lord, my
Wrongly mentioned it.
maybe, but
That doesn't mean.
maybe, my lord. But I won't urge on that point, my lord. My interim order was rejected, my lord. Paragraph 5.
Deceased employee, wife of the deceased employee, late इतना लिखना था, एक ही word रह गया. Wife of
थोड़ा चुप गया होगा, my lord. I'm so sorry, my lord. Maybe that's what it appears from the order, my lord. Now, my lord, my only contention was till the time the matter is disposed of, because now they're on a war footing, my lord, to appoint my stepbrother, my lord.
How they're on war footing by appointing this? Suppose if this this notice goes to them, then
Yes, yes. The fact is, my lords, my case won't be even considered. Now, I'm not praying for appointment. Appoint me on compassionate ground.
that is that is the matter
matter pending with the CAT.
consideration.
So, my lord,
Only been rejected or your candidature has only been rejected. That is the
yes. Yeah, what I only pray, my lord, a simple order, my lord, that till the time they should not, that is the only prayer, my lord. Lordship may remand the matter, my lord. In fact, my lords, there are two judgments, my lords. That issue has already been settled by the Honorable Supreme Court, my lords. That with regard to railways, my lords, the respondents were railways.
But of your this OA that state that from
My lords, at least because my OA
in very that whenever if they are going to appoint from their if they appoint say that it by moving fresh application or staying there.
my lords, that's what because my lords, the balance.
Too much.
My lords, if I may kindly place a judgment of the Supreme Court, 3 judges, my lords, authored by the.
That, if the that doesn't grant stay, I could should
It's
grant.
not on that point, but the issue,
That's-
but the main issue has been decided there, my lords, that on the ground of illegitimacy, my lords, a
that-
child of the second wife cannot be.
You want a finding on this fact which
I don't want a finding. I only pray, my lord. My only, with the deepest respect, my lord, my only prayer, Lordship may remand the matter back, and till the time the matter is not decided, or Lordship may say it should be
the matter
decided.
is pending, there is the question of remand. Still the matter is pending.
Matter is pending. My lord may dispose of this writ petition and give a direction that the matter may be disposed of within a month or two. Until then, there should not. My lord.
Pendency is with the this tribunal.
An expeditious disposal until then, my lord. My lord, because
Yeah, time the Supreme Court also gives us the direction that decide this
My lord,
is within time limit.
because
Will
I-
be able to do that or
I fulfill all the parameters for grant of
yeah,
an interim.
the
also.
tribunal is sitting idle, but then we will ask him that give them give the plan date to the hearing and decide it. They are sitting idle. They are not-
My lord, because unnecessarily I have to file a OA again, my lord, if in case. My lord,
unnecessary.
because the balance of convenience is,
Here, it would have better that you have
My lord-
another way there.
my lord,
That can't be.
test the parameters, my lord, for grant of an interim order. In my humble opinion, I fulfill all the. My lord,
The discretionary power. Can't put it in all the.
I leave it to your lordship. My only prayer was, my lord, that till then, my lordship would grant me some protection, my lord, at least.
You, at this, petition, it can't be liberty to request before they when the matter. That is the. With the request, the tribunal, they consider the same object.
I'll be very grateful with that order.
Petitioner and institutions may be allowed to withdraw. Petitioner to request the to dispose of the way number 2 of 2024 expedition.
And
Let's wait. Discuss the liberty paid for. If any such request is made by the for expedient disposal of the way preferred by filed by it, it is expected that the tribunal shall consider the same objective and make every endeavor to decide the way at the early.
I'm very grateful, my lord. I'm deeply obliged.
Item 24.
May please your lordship. My lord, as per order dated 21/8/2024, the other side were directed to apply this report as there are the status report of following the proceeding by notice 31/7/2024. And my lord, who have served a copy of the consent letter. My lord, the Pollution Control Board, my lord, issued a consent to operate letter dated 10/9/2020.
Supplied to you.
My lord. The copy has been served to me, but my lord, to WhatsApp I have seen, my lord. And there is no mention as regard the, my lord, my lord, manual, my lord, in mechanized loading and unloading system or vacuum loading and unloading system. There is no whisper at all. And there is no,
10/9/2024 page that.
my lord, that has been issued a WhatsApp copy, my lord. I have got it. I have managed to collect it, my lord. That has been issued by the Pollution Control Board. Letter of Pollution Control Board, madam. They should file it in an affidavit, my lord. They have sent WhatsApp copy to me, my lord. My lord.
What is your grievance now?
My lord, at this stage, my lord, the consent to operate letter indicates that missing about the manner of loading and unloading system.
That they have already, this specific conditions they have mentioned.
My lord, that condition should be
So
fulfilled.
manner of loading and unloading, why they are going?
My lord, unless my lord,
How this pollution control board can
my lord,
direct them manner of loading and unloading?
my lord,
They can only,
yes, that is
they
the
can
condition.
simply, they can simply direct that this air aspect, water aspect, plastic waste management, hazardous waste management, they have to be taken care of that. How this pollution control board can specify that you do this unloading or loading in this manner?
My lord,
What is their authority to say so?
my lord, when this loading unloading system goes on, my lord, in a mechanic, in a manual
they have
system.
imposed a condition that you have to maintain this thing. There is the question of manner of loading and unloading, how they can specify what is their jurisdiction to do so.
My lord, because of that, my lord, the as usual practice of loading and unloading is going on, my lord, manually, and therefore the pollution is going on, my lord.
Please be rational. How the pollution control board can direct them that do this loading and unloading in this
Then,
manner?
my lord,
What is their jurisdiction, sir?
that should be a terms and condition, my lord, for the
That
concept.
can't be the terms and that can't be the terms and conditions. They can only ask them.
That is the also,
These are the standards should maintain.
my lord,
Manner of loading and unloading, it's up to them.
my lord, in the
They
notice,
have to maintain all these standards which they have mentioned.
my lord, in the notice dated 30th July 2024, that has been categorized, categorically mentioned.
Yeah.
And the guideline also there, my lord. That has been annexed as a annexure number 2 by the affidavit filed by the Pollution Control Board in page 119.
consent of order, there are clear conditions which they have to maintain. If they will not maintain, then the law will take its own course. Nothing
My
more is required to be.
My lord, they are not at all concerned, my lord, with the, my lord, the problem created by the pollution. My lord, all over the world, my lord, as per World Health Organization, my lord, 7 million people are dying because of the air pollution. and they are not at all concerned. They are only, my lord, they are for concerned for the making money.
Yes. But it it got potential was Locus of a full like IH of Lincoln, pet book, book, another property of what that so this book taking book of should be this period as to the response observed by the big topic of the notice of the response. So, a response was typed on behalf of the public control. Then after of complaint of about the position was that Dhaka police Dhaka railway station on account of putting and picking of raw material as raw material. The raw material, the railway authority has issued notices to the pollution control board has issued notices to the railway authority in May 2024 and directed the railway directed it to take some measures to contain to take strict measures to contain the pollution at the Lanka railway station. Full stop. On subsequent dates, the responses were filed on behalf of the railways as well as the pollution control board, and ultimately the pollution control board has issued a consent to operate dated 10th of September 2024 to the Lanka Goods Shed Northeast Railway with certain general and specific petitions. Stop. The general petition provides that the gateway of the shall take steps to contain the potential and fluctuation during loading and unloading operations of the material of the specific conditions were also imposed in respect of air aspect, water aspect, plastic waste aspect, e-waste aspect, and hazardous waste aspect. It is also mentioned in the consent to operate order that the unit shall submit compliance report of the mandated conditions by every year to the member of the pollution control, to the member of the PCBA, as well as the regional office, Naga of PCBA. It is further mentioned in the consent to operate order that the Pollution Control Board, Assam, will have the liberty to withdraw the consent to operate order if adequate pollution control and safety measures are not taken and the mandated conditions are not complied. But the concept of the petitioner has submitted that in the consent to operate order, the Pollution Control Board has not specified the manner in which the loading and unloading operations are to be conducted. So, we are of the view that the consent to order, the Pollution Control Board has imposed general as well as the specific conditions upon the industry with the industry with the direction to maintain the pollution level on all the aspects, the pollution level under control on all the aspects. Full stop. Needless to say that if the industry fail to maintain the set levels and any and if also fails to maintain adequate pollution control and safety measures, the Pollution Control Board Assam is always free to take action in accordance with law. Again, that is, in view of the above, we are of the view that no further order is required to pass in PI. The same is therefore disposed of.
Item 25.
The argument begins. I'm for the responding bank in this matter. I seek some accommodation today that may come up after the vacation. Otherwise, they are protected by an interim order.
Well, I'm appearing about the petitioner, my lord.
this, you are not treated as a person agree.
Yes, my lord. That is one of the ground on which the appeal was dismissed, my lord, the locus standi. And I have a case, my lord, before your lordship, that I have a locus standi to challenge that possession notice, my lord.
There is no other order to challenge the order of the
My lord, the appellate tribunal, the petition lies first here before your lordship, and thereafter it can be moved to the honorable Supreme Court.
After the vacation.
My lord, I may be permitted to file one additional affidavit to the effect, my lord. One FIR has been filed by the branch manager against the then the branch manager who was involved in the fraud with the respondent number 6. There was a collusion.
You are the bona fide participant.
Yes, my lord. Recently I came across one FIR, my lord, that has been filed with the Bureau of Investigation of Economic Offense of Assam, my lord. I may be permitted to just bring on record that FIR. I have obtained the certified copy of the same, my lord. So there is an element of fraud also involved in this case, my lord.
It's the property mortgage was in the name of that person.
Yes, my lord. Say
Was
respondent
having the title.
Respondent number 6 had the title, my lord, at the time of mortgage, my lord. And it's one important fact I want to draw, my lord.
You find your whatever the
Yes, my lord.
Counsel for the, at the request of the counsel for the parties. The matter is that it is the same. With the execution. But in the meantime, the party complete their pleadings.
And the interim order is there, my lord. That may be extended.
So interim order is there.
Yes, my lord.
Yes.
Dated 8/12/2023.
Interim order, if any, to continue till next stage.
Highly approved.
27.
The necessary paperwork are completed and the other formalities also. So it is expected that the due amount will be released within a short period of time.
Actually, the gratuity amount has been paid, to a tune of 7 lakhs, and the pension that needs to be paid, my lord. There is from what I've received the instruction, Lordship, a tax has to be paid. So the moment the tax receipts are paid,
What is there to, keep this, but
the bills are prepared, Lord.
now they already working on
For the satisfaction, my lord, it may be kept
satisfaction of whom?
for us, my lord, because
We are satisfied. But they already paid the amount to you, 7 lakh rupees. Now the formality could be completed.
Once the tax receipt is paid, Lordship will pay the remaining amount. Bills are prepared, Lordship.
Only for the sake of this.
well, once
If
we
you can again, you can come.
well, once we receive the amount, the pension amount, the tax would be definitely will be paid, my lord, because we have submitted the statement before the authority. My lord, for the satisfaction for 1 month, my lord, after vacation, it may be listed, my lord. By that time, everything would be cleared, my lord.
Share of the that has not been paid.
Well, we have not received yet.
7 lakh मतलब share.
Let them receive the money, then only they will give you. Yes.
Not of the-
After.
Item 28 to 30.
Meet PJ Lord.
Yeah.
So with this matter, Lord, we have instruction to appear in respect of respondent number 6.
Oh,
Lord, respondent number 6, my lord.
what is the particular?
Lord, already represented, Lord, we see additionally engaged. But for that purpose, we require some time. Mr. DK Das, he's out of station, meanwhile.
Shortly the meeting on behalf of.
I am also one of the appellant.
Appellant.
In fact, at my instance, my lord, the judgment under appeal was rendered. At our instance, rather.
Hello, then item number 30.
My lord, basically, my both Chaudhurys are fighting. He is enjoying the cream.
Well, in item number 13, there is an application for condemnation of delay. Item 30.
That thing,
But here the,
Yes, my lord.
other appeals.
That may be, my lord, I don't have any objection in condemnation of delay. Huh?
That I may be, delay may be constructed, and appeal may be nullified.
Then all these matters can be, my
Yes,
lord,
that is
together and
it.
filed.
Post vacation immediately.
Okay, Mr. So and so. For respondent number 6. There's some time to argue the matter. Stop. Time paid for is granted. The IA number 2208/2024. Is filed on behalf of the applicant with a prayer to condone the delay of 31 days in filing the connected writ appeal. Stop. The IA has not seriously been opposed by the counsel for the by the counsel for the respective respondents. Hence, we deem it appropriate to allow the IA number 2208 of the 2024 and condone the delay of 31 days in filing the connected writ appeal. Full stop. The registry is directed to register the connected appeal and list the same along with the other appeals, on date take November की कोई first week की date.
Could it be on 11th of November?
11th of November 2024. Is there any interim order? Interim order is operation,
Yes, madam. Interim order is operating.
But nobody is operating, my.
but whatever it may be,
Yes, whatever interim order is
There's an
there.
interim order.
the interim order, if any passed in any of the writ appeals, would remain in currency till next date. Stop. This item number 30 this writ appeal में all the parties are
Yes.
Yes, we're all represented.
connected writ appeal. It is noticed that in the connected writ appeal, all the respondents are represented through their respective counsel. Therefore, there is no need to perform.
Only thing is, my lord, we will require the copy of the appeal.
Supply them.
Illegal.
My lord, on 16/9, there was an order to file affidavits. They have filed the affidavit regarding, my lord, that. All right.
Item 32.
Please, Your Lordship. Lordship, yes, steps upon the respondent has been completed, but we have not declared.
Yes,
Lordship, you have-
none is appearing.
No, Lord.
Yes, madam.
Lordship, may I request for bring on another date,
Have you paid the compensation or not?
please, sir.
Hey, but not to the damage. You invite the damage because they will pay the compensation.
Lordship, that, Mr. Arkady Surgery will be appearing in this matter, Lordship. Lordship, may I pass it over for the time being, Lordship. Time being.
Thirty-four.
It is complete.
Yeah.
It is complete.
It is complete, then argue it out.
My lord, this, then my lord, I can immediately
Immediately after vacation, lordship may fix it.
You can fix it earlier also. Why to fix it here?
Right. Well, there is an interim order because there is.
Interim order is the need to continue till next. Is the limited interim order?
Yes, ma'am.
There is an interim order, lordship.
Yes. Continue.
How like?
Item 35.
Lordship, in this case, going to file a rejoinder, 2 weeks time may be granted.
Yeah.
Supplementary list item 42.
Yes.
May please, your lordship. Okay, so issue is with regard to agents for election held in a cooperative society. Not, while holding election in a cooperative society, my lord, two aspects are very important. One aspect before the election and another aspect during the course of the election. Now, rule 3H, if your lordships kindly take up the Assam Cooperative Society's rule. Rule 3H provides lordship is taking up this book. Then page 110, my lord.
So this of the act,
Oh, I'm sorry. Rule. Lordship can have this.
yes,
So rule 3H provides that the registrar has to ensure a correct voter list by inviting claim and objections,
the concerned
delete.
executive secretary of the site shall prepare and submit a list of members eligible
Yes.
to vote in election number 23
Yes.
of the act to the registrar election authority for council site. Nature to fit the requirement of the type of type of exercise of the certificate of the respected of correct vote. Correct vote. Yeah.
So this is the first exercise that has to be done. Thereafter, my lord will kindly come to section 26(3). They are required to prepare two lists. One list containing names of valid voters, and another is
Previous corporate, I think 20 days of other of the they prepare a list of members to the right for vote of without the right valid for this that we vote of the members that we not support the mandate.
So, my lord, this is the second requirement. First requirement that the registrar has to,
Prepare that.
yes, he'll have to prepare, ask claims and objection. And then, my lord, two lists has to be prepared, and those two lists has to be affixed in the head office of the society, my lord. Asking the members to raise their objection if they have any. Now, if your lordships kindly come to page 76, it's the type copy, and lordship will kindly compare with 78, which is in vernacular. My lord, by this notice, they claimed that they have fulfilled rule 3H.
What is this topic?
My lord, this notice says that the shareholders of Meherpur Krishnapur Cooperative Society are hereby informed that the draft voter list for the year 2020-24 of the society is open in the office of the society. In order to finalize the voter list, if there is any dead person's name is included or any kind of objection, and for correction against the names of the dead persons, the nominees are asked to apply for substitution of their names from so-and-so to so-and-so before the undersigned. So they claim that they fulfill the requirement of rule 3H by virtue of this notice. Now, if your lordships kindly come to the vernacular version, this was purportedly issued dated 11/1/2023, claim to be issued. Now, if your lordships kindly come to page 78, right-hand side down below, signature of the secretary, date your lordship will kindly mark. So this notice was never issued, my lord. 11/3/2023. So entire process was,
Why you have not approached the tribunal for after this tender?
my lord, this was not even issued. Where is the question of me approaching a tribunal? So we raised the complaint, and pursuant to that complaint, my lord, the register of cooperative societies, my lord,
That is the vague order.
No, my lord, lordship will kindly see. I'll just come to you. I'll just take your lordship to the impugn order. It's not vague, my lord. No, the registrar being an my lord, administrative authority is not required to write a judgment, my lord. He has given reasons.
Judicial authority, what is this, where is this order?
Lordship will kindly come, my lord. Page 151. Yes, my lord. My lord, he gave 4 reasons, 2 with regard to the voter list and 2. Yes, my lord. May I read, my lord? In pursuance of the order of the Honorable Guwahati High Court in case number so and of the complainants of so and so and 10 others dated so submitted before the Honorable Minister of the Department and the undersigned regarding AGM of Meherpur Krishnapur Society, a hearing was conducted on 7/9/2023. The Honorable Court has set aside the earlier order dated so on the ground that it was violated. It has violated the principles of natural justice in as much as the petitioners were not heard. The court, however, has not dealt with the merit of the dispute involved in the above.
Para number first.
Yes, my lord, heard the petitioners, man.
Yeah.
Heard the petitioners and responded.
And so deep this para.
Peru,
Heard the petitioner, the respondent, Peru, yes.
yes, peruse the documents submitted by both the parties. It is seen that the voter list of Meherpur Krishnapur Cooperative Society Limited Part 1 and Part 2 has names of many voters, the fact of which is substantiated by the death certificate of the voters submitted by the petitioner. 35 pillar with my limited
Where
list.
is that detail?
I have annexed in the.
You have annexed, where is the order says, sir?
My lord,
Order.
if I may just submit, my lord, one thing.
It's
My lord,
very vague order.
no, this, my lord, even if these documents, my lord, I
That is,
submitted.
it is also seen the voter list is also names of many members.
Yes, my lord,
written
he
twice.
has,
Which are those voters? How many of those voters are there?
my lord,
And it should so is the view that this voter list was that.
Yes.
But when the elections are that is how did the
my lord, election is subsequent. My lord, the first thing is that, my lord,
elections
out-
there was no contest? How is the
in fact, my lord, my humble submission would be, my lord, the very sanctity of the entire process goes. My lord, in what manner they got elected, that's a different thing altogether. They have elected uncontested.
ultimately the
But-
voter list is for the purpose of this election?
My lord,
If the election
is-
has not taken place, then
no, lordship is absolutely correct. Voter list is for the purpose of election. But the primary mandate of the registrar is to prepare a valid voter list following 26(3) and 3H, my lord. And that was apparently flawed, my lord. If the voter list is so sanguine, in fact, my lord, one aspect I'd like to point out.
size the voter list is only for the purpose of electing.
My lord,
When the
lordship-
elections are not taken place, even though it's a certain regulation is there, how that election could be affected?
My lord, may I just explain, my lord? Lordship has seen the notice dated 11/1/23, my lord. It was never issued. That is the start point of the entire issue. And the learned single judge, my lord, while narrating, because there no affidavit was filed by the corporation department. Yes. So whatever the facts were there in the writ petition, my lord, the learned single judge has thought that those are correct.
For the cooperative department,
My lord.
if not concluded before the land.
In fact, my lord, what has happened, my lord, the issue boiled down, my lord, to one aspect of the matter. Whether the impugn order at page 151, my lord, it suffered from any infirmity or not. My lord, that was essentially, my lord, it was a question of law.
Notice. That's what to accept notice on behalf of.
My lord, only one point, my lord, I am supporting the impugn order.
albeit on a different ground, not as my lord made by the petitioner.
Yeah.
What the my lord essentially the my lord register had said that the proceedings of the AGM is tainted with illegality. Now, so far as the findings, my lord, of the register is concerned, that was absolutely not under challenge.
Let the other party.
Lord, I have a small interim prayer, my lord, of stay of the order passed by the honorable single judge, my lord.
How it will affect? What will happen?
Lord, I'll satisfy your lordships, my lord.
What will happen to that? Elections
the
are not
effect
going
is
to
that
be
for
interfered with. Elections are not going to be interfered with.
No, that's not, I'm saying, my lord, consequential order should not be passed
Notice
because
the rate appeal as well as the IA number so and so, returnable on so and
My
so.
lord, an illegal vote will come into play. my lord.
illegal
After
vote
it
will
is
come into
constituted,
play.
legal consequence will, my lord.
Sir,
be
we have not
5
passed
years.
any order.
No, my lord, once, my lord, this order is, my lord, interfered with.
Sir,
150
we have not interfered with.
No, my lord, the
We
honorable
have
single,
simply,
my lord, what I'm trying to say, honorable single judge has interfered with this order,
Yes.
151. Now the consequence is, my lord, the elected members, my lord, they will in terms of the mandate, they
Form
will,
the
my lord,
board.
now constitute the board. Once
For 5
the board
years.
is constituted, my lord, then, my lord, legal consequence will follow. Then again, my lord,
so what do you want?
my lord, I want, my lord, that the honorable single judge order, my lord, should be, my lord, stayed.
Please, file an appeal. You have not filed any appeal.
I'm not filing, my lord.
Then file appeal. Then only
Lordship,
we
at least consider my prayer that any consequential order should not be passed by the corporation department, my lord.
We will not
Person-
pass any order without hearing the other side. Please. And they have accrued their right, they have elected, they elected,
Uncontested, my lord, there was no election, my lord.
but ultimately,
My lord, there is another story, my lord, the notice which was given, handpicked someone, my lord, it was, the election notice was also circulated in a closed group, few members, my lord.
let they come, let they.
Much of, much of.
Earlier, he was there in this.
Yes.
Item 29.
It will take some time, my lord,
It will take some time.
some time.
But the matter is-
Actually, basically, my lord, we are alleging rampant corruption by the erstwhile BTC administration. We have given all facts and figures. After the vacation,
Item 40.
it will go in the-
Time for the respondent, my lord, the repeat. The the have written me that
Mr. Chakravarti, you produce some this orders on the previous hearings.
Original of that undertaking, Lordship.
Undertaking, and there was some this communication between that how that undertaking is to be.
Yes, yes, Lordship.
That is there.
Lordship, that I have a copy. Last time I also submitted, and I'm submitting it. Right?
Yeah, you please.
since the act has come in 2006, Assam Rifles Act, and there is also rules.
Now that certificate is.
That Xerox copy has been annexed. Last time I could not produce the original one. Now I have the original one, Doctor.
Where is that?
This is a clear case, my lord. Lordship, Section 8 of Assam Rifles Act. Lordship, kindly have a look. Regarding resignation. That will clarify everything.
Yes.
Lordship, kindly have a look. Firstly, the Assam Rifles Act 2006.
Yeah.
And in the bottom, Lordship will find that notification came into operation on 20th February 2009.
So, this, you are referring to Assam Rifle Act 2006.
Lordship,
Clause, Section 8.
Section 8, man.
Read resignation
Section
and
8. I'm reading, my lord. Resignation and withdrawal from the post. No member of the force shall be at liberty, A, to resign his appointment during the term of his engagement, or B, to withdraw himself from all or any of the duties of his appointment, except with the previous permission in writing to the prescribed authority. There is no previous permission. No previous permission. On the day of 12/8/2011, I have been forced to submit the resignation. There was no previous permission, and thereby it's all about the making the story by the authority concerned to force me to resign. Now, Lordship will see the rules. Assam Rifles Rules 2010, Lordship. That is with your Lord.
Yes.
Lordship, kindly have a look at Rules 27, madam. This provision will clarify the case, my lord, everything.
27. Yeah.
Yes, 27. Resignation, madam. My lord, the central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before completing the term of engagement, provided that before granting such permission, the central government may require the officer to refund to the government 3 months' pay and allowances drawn by him or the post training imparted to him, whichever is higher. For this, pilot notice is necessary. Nothing has been given. The central government may accept the resignation under sub-rule 1 with effect from such date as it may consider expedient. 3. The central government may refuse to permit an officer to resign. A. If an emergency has been declared in the country, either due to internal disturbance or external aggravation, or B. If it consider it to be expedient so to do in the interest of the discipline in the force, or C. If the officer has specifically undertaken to serve for a specific period and such period has not expired. Now, 4, Lordship, whether this rule will applicable or not to this enrolled person. The provisions of this rule shall apply to and in relation to subordinate officer and enrolled persons. I am the enrolled person, my lord. As they apply to and in relation to any officer of the force and the powers vested in the central government under sub-rule 1 and 2 shall be exercised in the case of a Subedar Major and Subedar by an Inspector General, in the case of Naib Subedar by an officer not below the rank of Additional Deputy Commissioner, Additional Deputy Inspector General, and in the case of enrolled person by a command. But since the provisions are very much clear, my lord, previous permission must be there from the government. And on the particular day, my lord, 12/8/2011, I have been under duress to submit my resignation. On the same day, the committee was constituted. On the same day, committee convened. On the same day, the order was passed against me, my lord. How can it be so fast, my lord? Had there been my lord, the very purpose of convening the meeting, standing committee, is to examine the person, my lord, individual. No such evidence has been taken. No such statement has been recorded. And the very purpose of doing all this resignation, my lord, as because the petitioner was on leave, medical leave, my lord, for 3 months. Recently, they have written a letter to me, my lord, saying that the writ appeal is pending, and we'll consider as soon as it is come out, if it is considered by the honorable. Actually, this
What you are arguing here.
that has never been raised.
The principal judge has not decided the restriction of this ground.
The point has not been raised. Though in the writ petition and the affidavit, it has been raised, but it has not been decided on this issue. Only the issue has been decided by this honorable court by calling the record itself from the authority concerned that since in the CRPF matter in 1990, there is a circular.
How the CRPS circular is applicable in this present case?
CRPF circular means the honorable court said that since the principles regarding undertaking, my lord, when a person goes for the resignation, for resignation or for anything else, for discharge, anything else, in the particular circular, it has been said that he has to ask about his the economic condition, whether after the retirement or after being discharged, he can do anything for the livelihood of the family or not. These things are there. Only Lordship, kindly have a look this circular, madam.
But this circular, where the dealt with this circular, that it is applicable, though it is in relation to the CRPF, but it is applicable in this Assam Rifle employees also. Where is that?
Lordship, kindly have a look. Yes. 25, Lordship. Paragraph 25. Para 25, Lordship, of the judgment. 25, 26,
Yeah.
28, 29, my Lordship, is a very important. In this regard, a reference has been made by the learned counsel for the petitioner to a circular issued by the CRPF to ensure that any such application sought for discharge or seeking voluntary retirement is to be considered by the authority to ensure that such application is not submitted under duress but purely on voluntary basis. In this regard, it has been submitted by the learned CGC that the circular is not applicable to the Assam Rifles but to the CRPF only. This court.
Yes.
Now, Lordship, this court is of the view that it is a too technical objection and the Assam Rifle Authority ought to apply the same principle while considering such application for voluntary discharge as raised in this petition. This court is of the view that standard adopted in other paramilitary forces can also be held to be applied for the reason that it merely lays down certain precautionary measures to be taken by the authorities before accepting any discharge application by ensuring that such application was made voluntarily.
Case, there is no such whatever the guidelines are there in the Assam Rifle. But if they are having their own instructions or guidelines, why they go to why they rely on the CRPF guidelines?
That particular now Lordship will come. Next paragraph.
Yeah.
Yeah. The aforesaid circular has been issued for the benefit of the employees. This court is of the view that there is no reason why similar criteria principles should not be adopted in the Assam Rifles also. Even if the said circular was issued exclusively for the CRPF personnel and not applicable to the Assam Rifles. This court is of the view that any procedure adopted by the authority while taking any administrative decision must be fair, reasonable, keeping in mind the mandate of Article 14. Therefore, these precautionary procedures can be read into the existing rules of the Assam Rifles for the Assam Rifles authority or any authority cannot deny the reasonable.
But they are having their own guidelines.
Malat, regarding this, Malat, I'm submitting Malat regarding this. Malat, whether any circular, anything is there or not, Malat, this government advocate were requested 3 times to obtain the instruction, Malat.
Now they have produced here.
No, in the single bench, they have failed to produce and accordingly considered.
Where is that? That despite granted opportunity.
My lord, in my affidavit, I have stated.
But once they are having their own guidelines, this is what their guidelines of 2009. And as per the said guidelines, the authorities concerned or the committee or whatever the standing committee is required to obtain a certificate of this effect that submitted by voluntary petition without any duress and all that is there.
No, here, my lord, in the discharge, when undertaking was taken, my lord, or when the committee was constituted, the committee was constituted to examine the application of the petitioner or the respondent here, that whether that application was submitted, resignation was submitted voluntarily or under duress. That question.
So
that question was not
of the committee.
That question was not decided in the committee.
This 24th of May March 2009, this guideline or whatever it may be, what it says.
That guidelines I do not know.
Okay.
And that guidelines was not produced by the CGC at the time of when the.
Sir, if it is there, either you say no such guidelines are there. If it is there, then
that part I do not know. Now only my grievance is this, my lord. Since there was a committee had to take the statement.
So you just go through it. What the committee is to do? Go through it.
Premature discharge before pensionable pay. I have to check out otherwise. But thing is this, my lord, when this is the letter of 24th March 2009, and subsequently the act has come, my lord. This the act will this act Assam Rifles Act cannot be overlooked by this. This act is very clear, my lord, regarding resignation. This act is very clear, my lord. That has not been looked into by the authority, my lord.
But that has been taken care of. That.
No, here it has not been taken care of, my lord. The lordship kindly see, my lord. Again, I'm reading, my lord. Section 8, my lord. Again, I'm reading.
Yes.
B. To withdraw himself from all or any of the duties of the appointment, except with the previous permission in writing of the prescribed authority. Where is the previous permission, my lord?
This is there. It's there.
In 2010, 2012, I have been discharged. And
2011, you.
Yes, 12/8/2011. No, the discharge was made subsequently on 1/1/2012. And in earlier occasion, 12/8/2011, I have submitted my application on the same day. And same day convened the committee. The committee did not ask the petitioner whether you voluntarily resign or under duress. That part has not been acted. And here, my lord, the previous permission, there is no permission. Okay.
No, that's not fair. The question regards the validity of your discharge certificate. That discharge of the certificate is automatically settled by the learned single judge in the earlier. The matter was remanded only to the extent that whether the prayer for withdrawal of the certificate is to be accepted or not.
That part, Lordship, in the order, it has been said. Lordship, kindly see the honorable court order.
2015 order.
Yes, that order, Lordship, kindly have a look at in the subsequent order, madam.
Subsequent order.
In the subsequent, the 16, Lordship, kindly have a look. That part has been already.
Yes.
Lordship, kindly have a look.
Page 60 of the paper book.
In the the subsequent honorable court's order,
Which subsequent order?
that is 28/2/2019. That earlier order,
Come to this page 60.
earlier order has been reflected here. That is, that particular order was not passed on merit. Taking an overall view of the matter and without commenting upon the rival contention advanced by the parties, I am of the considered opinion that it would be need the end of justice if a similar course of action is adopted in the present case as well. Accordingly, without interfering with the discharge certificate that is case is
Accordingly, without interfering in the discharge certificate dated 3/12/2011, the case is remanded back to the Office of the Director General Assam for fresh consideration of the grievance of the petitioner as discussed above.
Thereafter,
now, what was your grievance? That though I was discharged on 12/8/2011, but I moved an application for my withdrawal of that discharge application on 26/8/2011, and they have not considered. This was your case before the learned thing. The learned single judge relying on the earlier judge passed by in one of the other writ petition, wherein they wrote that writ petition was disposed of, considering all the above, para number page 59. While not interfering with the improved order of discharge from service, the matter is remanded back to the Assam Rifles Authority to examination of the case of the petitioner afresh as to whether his prayer for withdrawal of the resignation from the services and reinstatement in service which he has made in 90 days of acceptance the discharge from service can be considered in view of the fact that circumstances indicate. also the demand law to consider your request for withdrawal of your resignation.
Now thereafter, Lordship will see the impugn order.
Yes, now come to the,
61.
yes, impugn order.
They are relying the central service rules, man. 61. 5th of November, 2015. Last one, Lordship, last para. Therefore, in the difference to the directions of the Honorable Guwahati High Court, the matter is re-examined here. The rule 26.4.3 of Central Civil Services Pension Rules 19 lays down the appointing authority may permit a person to withdraw the resignation. My lord, how can it be, my lord? The resignation in the public interest on the following condition, namely pension. My lord, is it the fact, my lord, only pension matter will be decided under these rules? Had there not been the Assam Rifle rules, the matter is different. But here, that has been decided under 26, saying that the period of absence from duty between the date on which the resignation became effective and the date on which the person is allowed to resume duty as a result of permission. But I'm not the this petitioner's case doesn't come within the Central Civil Service Pension Rules 1972. Since there is a regarding this resignation or termination, all these things, there is a particular rule, Assam Rifle rules. If the Assam Rifle rules is ignored in all the time, how this petitioner will get justice? All along, they are relying the Central Civil Service Rule, Pension Rules in 1970. Lordship, kindly come to the page number 92, my lord. 292. Para 17, my lord. Learned CGC has also produced the relevant records about the proceeding of the standing committee and other proceeding relating to features of the petition. Before this court proceeds to deal with this matter, it may be noted that though the petitioner had earlier approached this court by filing WPC number 22, raising various pleas and contentions of the Assam Rifle authorities, also had given their justifications and explanations for the same. The court did not go into the merit of the case as clearly reflected in the effective portion of the order and remanded the matter to the Assam Rifles Authority for reconsideration. It was observed as follows: taking all suspense accordingly without interfering principles. Let the aforesaid exercise be completed within period of 2 months from the date of sentence. Since the court in earlier instance had not decided the issue raised therein, this court is of the view that it may be permissible to examine the issues on merit
That is,
in
here
this
we have,
present petition.
here we have,
My lord, be that
we are some doubt.
so, my lord, since in earlier occasion, my lord, it was referred back. Had there been decided, my lord, the matter is different.
Referred back,
And to go
remanded
to the-
back on what point? With this observation that I am not going to, without interfering with the discharge certificate, 3/12/2011.
No,
That was not interfered with. That is the question of remanding. Remanding only up to the extent that whether once you have applied for withdrawal of that is permissible or not.
Now, my lord, question comes, my lord, when this honorable single bench has considered and disposed of the matter on the basis of the merit, my lord, considering all these aspects.
Whether
The
this was
petitioner
open-
now, as because lordship is taking different view,
No, not
now
taking
should
different view, whether you just satisfy whether in the given facts and circumstances of the case, the mandate signature can look into the discharge certificate, validity of the discharge certificate or not. Can examine the validity
No,
of
that
discharge
part also-
certificate or not.
that part also decided, my lord. That part also I'm saying, my
Yeah.
lord. Lordship kindly have a look.
Yeah.
This it starts, my lord, from at 19.
90,
1919, my lord. Para 919.
19.
I'm reading, my lord. Be that as it may, the main thrust of the argument of the learned counsel for the petitioner is that the application for discharge was not voluntarily submitted, but was submitted under duress under the circumstances.
This was very much the point before the learned single judge earlier also.
Yes, my lord.
This was throughout your state was this.
Now, lordship, kindly help. Now, lordship's query will be replied, my lord, here. If the discharge application submitted was not voluntarily as contended by the petitioner, and if it is true, such decision of the authority to accept same may be liable to be interfered with. On the other hand, if the discharge application was submitted voluntarily as contended by the authorities, it does not call for interference by this court. Now, lordship, kindly see as to whether an application for discharge which had been submitted by an employee was voluntarily or not is a pure question of fact which perhaps would not be appropriate for this court to decide. However, if there are sufficient materials to indicate that such application was not voluntarily submitted, perhaps this court would be within the jurisdiction to interfere with the same. Accordingly, this court will proceed to examine whether any such facts or circumstances have been revealed in the case which would indicate that such application for discharge was not voluntarily made.
That what we are that all these questions with the learned single judge posed on himself or referred to it, whether he can go into all these aspects.
But since
Once here pressing a prima facie that we are of the that discharge order that not be interfered by the court in the earlier litigation or earlier litigation. Whether this was open for the single judge to again reopen that issue.
my lord, that part, my lord, had it been not decided, had it been dismissed on this plea, then and there I would have come before this honorable court for division bench.
Ultimately,
this
we are in writ appeal.
Since the single bench has considered, my lord, so I was under the legitimate expectation that the court will be, court was rightly
So
passed the
that's why
order.
Only now they have come here.
And
sir.
now, after about, now after passing of this 19, my lord, now it is 24. If lordships take the different view and my
Is it not permissible, sir?
petitioner will suffer.
Is it not
My lord,
permissible?
I'm not saying, my lord, I'm not saying so much.
So then,
I'm only saying, my lord, after 6 years, again for the same,
sir,
the petitioner will suffer, my lord.
reinstatement order was passed after 8 years. So what's wrong in that 6 years?
My lord, it's lordship's view. I cannot.
You were discharged in the year 2011 and the court has reinstated you in the year 2019. So that can't be a
It's
ground.
lordship's view. I cannot do anything, my lord, except submitting my prayer, my lord,
No, no,
before
that's why
lords.
only we are giving you the opportunity.
Yes.
You please try to convince us that yes, it was open for the circuit single judge to go into the merits of the case again, merits of the discharge. Once it was upheld by the circuit single judge in 30th petition, again it was open for it. We are granting you open. That's why only we are raising you.
Only my grievance and the prayer before lords is this, my lord. Since all these matters has been decided by the honorable court after perusal of all records and all these things, and view was taken, my lord. And now, my lord, since in last occasion also, lordship told me that when the honorable justice S. Syam was here with your lordship's manner. That time, after considering all this aspect, I've been told that you will be paid the.
So we are bound by that.
No, we will be
Whatever
paid
we have
the.
discussed in the court, now we can't ask any other question.
No. After length of so many argument, my lord, that was taken the decision. This view, my lord. Now, lordship, since
What
in
do you expressed on that day?
that instead of reinstatement, go for this financial. This.
Yes, it's just nothing, no concrete something.
The
It's
financial
simply a
benefit.
suggestion to a way out, but that doesn't mean that we have expressed the opinion and that opinion is final.
No, I'm just submitting for lordship that is.
That's right, sir. But now this question has come that if the target single judge has already find that there is no case for the discharge offer and presented the matter only for the purpose of considering request of your withdrawal of petition. Is that open for the another single judge to look into the merits of the case?
Now, as a whole lordship, leaving all this aside, now lordship will consider, since I'm before lordship, since the act is there, my lord, Assam Rifles Act. The Assam Rifle Rules 2010 is there, my lord. Now, leaving all this part, my lord, if your lordship considered that since in earlier occasion, in April 2011, my lord, I was in the medical leave for 3 months. For that, I have to suffer today, my lord, because I have been under pressure to give the.
Then many
No,
questions will. Then many questions will come up, sir.
No. Only I would like to say.
Questions will come up because they have mentioned series of incidents.
I had to
where
suffer.
Discipline was there.
Now only my point is this, my lord. Since whole this the resignation itself made in law.
We are granting you what opportunity to convince the court that yes, for the target because they could look into the matter regarding your this discharge once again by deciding the second petition can satisfy us. Will fixing this matter day after tomorrow.
Sometime will be required.
No, day after tomorrow is
Next week, lordship.
not next week.
Day after tomorrow, my lord, some problem is there.
Thursday. Only on Thursday.
Next Thursday.
This Thursday.
Today is tomorrow. Tomorrow is Thursday.
Tomorrow is Thursday. Okay. Friday.
Not Friday, my lord. Can it be on Monday or like this, my lord? Which day?
Not possible. Monday, I think so. This bench is not available.
As Friday cannot be, my lord.
Which Friday?
Lordship saying this Friday or another Friday?
I'm saying another Friday.
Sometimes.
Acha, we are discussing this matter on 27th.
Lordship? 27th.
7th of September.
No, my lord, not 27, my lord. After, my lord, some problem is there, my lord. There were 31 or like this.
We have heard the learned counsel for the parties at length.
I have to go through all this judgment, my lord.
We have heard the learned counsel for the party. It is noted that the discharge order issued in respect of the respondent was subject matter of state before this court. By party before this court party. For subject matter writ petition number 7056 of 2023 referred on behalf of the respondent. The learned single judge, by disposing of the said writ by the order of 50 has expressed has specifically while disposing of the petition, while remanding back the matter to the office of the Director General of Assam Bank, has made the observation that no interference that he is not interfering in the discharge certificate dated 3/12/2011. Stop. Now the question arose whether once this court acts refused to interfere with the discharge certificate dated 3/12/2011, whereby the respondent was discharged from the service of the Assam Rifle. In the subsequent petition, it was open for another single judge of this court to examine the validity of the discharge certificate dated 3/12/2011. So, the concept of the response takes some time. Advance in the arguments of this article. This matter after Puja vacation. Puja vacation. If this court place the
If there is a case, if there is a case, some factors you want, whether voluntarily done or not. Voluntarily done, or this the same question was raised, whether that was voluntarily done or not. Some factors you want. The court held that those are disputed question of fact court cannot look into.
This is on record of that.
Item 41.
Okay.
I was asking my learned friend whether it's a case to be done before the vacations. Slightly.
Chaudhary is not in mood.
He appears to be
Since
exhausted.
morning, he is not in mood.
He appears to be exhausted. After that, proceed.
After which. My lord, the interim order will have to be extended.
Interim order, then it will be extended next.
Can it be on a fixed date, 4th of November if it is?
Whatever date.
4th of them.
At the request of the it's for 4th of November. 4th of November, yes, what?
November.
There's a wedding in his family, so.
In the family or your wedding?
No, own family, his brother.
His brother. He's already married.
Not yet.
Not yet.
The brother could be elder also, my lord.
That's why only.